Well, I just put them down, so I don't know.
The office will be.
Yeah, I don't need those, you know, so.
Those look fresh.
My dad's taught me about this.
Good afternoon, everybody. I'm going to call this meeting to order. It's a workshop for the City Council of Long Beach on Tuesday, June 25th, 2024. If you have a cell phone, if you please put it on vibrator or turn it off, that would be greatly appreciated. And Mr. Presetti, you want to start us off?
Thank you, Mayor and Council. So we have prepared a presentation today to go over the topic of code enforcement. Want to discuss some of the background, some of the processes, some of the things that we talked about at various times. So from there, I'll go ahead and get started.
Absolutely.
So some of the topics, like previously saying here, I'm going to kind of go through a summary of code enforcement, some of the ins and outs of what's required. A lot of it's governed by Florida statute, Chapter 162, as well as some of our local procedures. Discuss the code enforcement board and special magistrate, kind of that situation and discussion there. Go into more of our specific procedures, prioritizing, discussing case types, complaints, and then some of the updates and things that we've been working on over the last few months. So first, I did want to start off with really the goal. Code enforcement, our goal is to gain compliance. It's not here for punishment. It's to make sure that we have a set of rules, a set of standards that we want everybody playing by the same set of rules to really accomplish the goals that we have in our community. And so with that, kind of transitioning into why do we have code enforcement? Why do we need codes? It comes back to the community's goals and visions. And it's kind of a full circle effect in that we all what separates let's say City Falls and Beach and cities in general, is that we have a certain set of standards and expectation for our city to set ourselves apart. With that, we want to develop good plans, which roll into the municipal codes that we have through our code of ordinances, through our land development code and various other codes, and to make sure that we've now established that expectation, that level that we want to provide to the city. We have the code enforcement side to help come in and make sure that everybody's playing by the rules and following the rules and the standards that we've set for ourselves as a city and that we have going forward. With that, some of the reasons, again, going back to why we set these community goals and values initiatives, we look at land values, trying to improve safety, community image, sense of community, the quality of life, also, decreasing, some of the attractive nuisances, it's the kind of, I know, as we've all heard, kind of broken window syndrome that, one leads to another, that, if you have one nuisance property, people maybe start thinking that's the kind of level of what to expect in an area, and it kind of all goes downhill from there. So, what we do is try to tackle them, piece by piece, property by property, to keep that level of standard that we've established as a city here. So, moving into one of the topics here that I know we've had some discussion on here and there is the code enforcement board, and the special magistrate. For many years, we've had a code enforcement board here at the city. It's filled by members of our communities, citizens that volunteer. They do a good job at it, and we've been fortunate for a lot of years to have the code board. More recently, the topic of special magistrate came up. It actually first came up back in 2021 during a CRA workshop. Actually, it was in June of 2021. We were having a CRA workshop, and the topic of quality of life and kind of that community, appearance and some of those topics came up for discussion. And during that workshop in June of 21, we were talking, Chief Page was up here as well, talking about some of the things that can be improved as far as at parks and some of the other, issues that we've seen downtown. And during that discussion, the kind of idea of a magistrate came up was, hey, is that something that would help expedite this process, get us to where we want to be? And so from that point on, in 2021, we did do an LDC amendment. There was an ordinance that was approved by City Council in late 21 to allow for a special magistrate. And then once that was in the code to allow for a special magistrate, moving into 2022, we did put it out to bid to hire that service. Took 2 go-arounds. The first go of that bid didn't receive any submittals. And so on the second go, we actually had Kim Kopp that was initially awarded and chosen as the first magistrate for the city. Moving into 23, we had her first hearing before she moved on to the city attorney role. So that was put back out to bid late last year. It was awarded to Anchor Smith and Grimsley, to the Bowmans, there, Kyle and Steve. And so really starting this year, starting in January, we started kind of rolling forward with the magistrate hearings. To date, we've had 5 hearings, more or less monthly here with them. It's been working well. To explain what that magistrate is to everybody, really it's an individual, it's an attorney, it's someone, a licensed professional that is knowledgeable in the law, in our codes, in state law, to really evaluate the cases in front of them as a non-biased individual, not taking any personal opinions or anything into this, but looking at it based on the facts at hand of the case and making a decision, rendering a decision based on those facts. So, I'll say from staff perspective, we feel that it is a bit quicker, more expedient process. Simply, as one individual there, you have one person that you're explaining information to, and it's one person asking questions and rendering a decision. Not to say it's the only way or the best way it can be done, but that's from our side something that we've seen in that, as well as scheduling. If we have to reschedule or move hearing dates around, it's just for a staff perspective, it can be easier to deal with that one person to try and get these things lined up versus the board for reaching quorums and so on. One of the things to note with the magistrate, as the code board as well, is that a case that goes in front of the board or the magistrate is typically, staff will recommend an administrative fee of $325. That's been the standard for many years, and that cost is to offset the actual administrative cost of bringing somebody, a violator, through the process and going to that board of the magistrate. The intent of that is to offset and cover that cost of the magistrate, so that it's not back on taxpayers and coming out of city dollars. It's assessed to the violators. One of the negatives, I think maybe it's kind of hit on, but directly to hit on, is that going with the magistrate does remove that level of citizen participation. So there's pros and cons to each side here, but I did want to explain that process. Are there any questions on that, or would you rather I just kind of move along as I go here? Up to.
Mr. Berry?
Magistrate fee is $125 per hour or $125 per case?
It's per hour. It's billed to the 10-minute increment. So for the magistrate hearings that we've had so far, we're averaging about $600, $650 per hearing for their magistrate hearing is what we're averaging so far this year since we started with them. Each case is assessed a $325 administrative fee to offset all of the cost of the magistrate, of certified mail, and all the notices. That $325 fee is assessed at the discretion of the code board or the magistrate. Staff will recommend for it, but it's ultimately up to the magistrate or the code board whether they want to assess that to the individual.
To the individual that has infringed on the code enforcement?
Yes, ma'am.
The code?
The code, yes.
So.
Mr. Alvarado?
How many times, and this might be a question for Ms. Barnes as well, but how many times during the last 2-3 years have we not had a quorum with a code enforcement board?
Just a guess about the county.
Yeah.
I know there's been 3 or 4.
Probably a couple dozen.
Yeah.
Okay, so somewhere between 3 and 6 over the last 2-3 years. 2 years. Okay. And I know that that's something that we advertise for through all the same means that the city advertises any open position on a board, social media, etc.
We would. We have not advertised this one because of the special magistrate being appointed.
Gotcha.
Discussions between several people have said we need to wait until the council decides whether we're going to continue with the code board or go with the special magistrate, because we don't want to ask people to serve on a board and then all of a sudden dissolve
Sure.
it. So we have not advertised for it since the special magistrate.
Gotcha. Thank you. Thank you, ma'am.
Thank you. Other questions from council? Ms. Weiner?
Is the magistrate, is it 1-year terms?
Yes, they're under contract with options to renew as we move forward. The contract was for an initial 1 year with a couple of years of optional terms to renew.
And it comes back to council yearly?
Not within, so the initial contract has those optional terms that we could renew at the staff level with the city manager. Once that contract runs its course, we have to go back out to bid. go through council to award at that time.
And I know we've had a couple of cases come before. Seems like it was over on Moriarty that was such a large dollar figure. What brings a code enforcement case? If a citizen shows up before the magistrate or code board, they show up there and they don't like the resolution, what are their options?
There is an appeals process through circuit court. I know Mr. Burns is.
I can, they would have to appeal to the circuit court within 30 days.
So just thinking about the one over there on Moriarty that came before us, and I know there was one or two right around that
Yes.
same time that we all looked at, and we either felt as a council that the charges and fees and penalties, maybe not the code itself so much, but those fees were excessive, or communication efforts had not been, perfected, for lack of a better word, and we as a council took it upon ourselves to somewhat override. Imagine the magistrate and or the board played a part in saying, it's going to be daily fines, monthly fines, until it's fixed or cured or whatever else. And then somehow they ended up here, not in the circuit court. I mean, and, I would love for a citizen to,
And
I'd like for it to be clear if a citizen's not satisfied or they feel they were wronged or something's misunderstood, that they can come to their representatives instead of going to the circuit court, which is very costly. But we're already here, and we apparently have some role in
Sure, and
those
in
things.
our code of ordinances and in chapter 162 statute, it identifies those certain situations. So like in the cases that we've had here in the past, they were for either a nuisance abatement action or a foreclosure action. And those are the actions that we have identified in our code that comes in front of city council. So not the order 1 or order 2 process that would go in front of the board or the magistrate, but if it's already got that process running on it, and we want to take further action to potentially spend city dollars to bring it into compliance, or go through foreclosure, that's where it would come in front of the city council. So that is true. There's another process through council, but it is identified in the code of ordinances and in statute for the foreclosures.
Thank you. I think while we're here, my recollection of those previous cases and some of the big griefs I had with them were I've mentioned I do evictions, and when I go to the courts, if your T's not crossed and your I's not dotted and it wasn't signed and wasn't received and wasn't certified and wasn't received and sent back and all that kind of stuff, you didn't serve them. Mm-hmm. And so I've watched a couple of the cases. I've been to a couple of the cases here by the magistrate with Ms. Cobb anyway at that time, and I've watched a couple since. And the major complaint that I've heard from citizens is, I didn't know, I wasn't served on, I didn't have time, and now here I am, I'm getting administrative code. Had I received this, and that was the most recent one I was involved with. She had got called a voicemail, left it, but it was the wrong person, but it was the one that was written on here. I'm just not confident of the process leading up to the magistrate appearance before the magistrate. What have you done to see that process is improved, or in the legal sense is perfected service upon an alleged defendant, a violator rather?
Sure. With those, we even look back to those, because we hear that too. I will say, without a doubt, that we did go through the process correctly on those. We do hear it from individuals saying we didn't know, we didn't hear, but any of those that have gone to the magistrate or the code board, those that have come in front of you at council have been reviewed by either our current city attorneys or past. Our I's are dotted, our T's are crossed when we come through those. We continue to do so, but I can confidently say we're not taking any through that didn't go through the formal notice processes as required per statute. Didn't have orders recorded and so on. It's unfortunate that we still hear that, but I will say that we have followed all the requirements of those as they come through the process.
Mr. Meade?
I think we all looked at this workshop, or I'm assuming we did, from a different perspective. My hope today, and it seems like we need to discuss the magistrate, but my hope today was we were going to focus on what do we expect from staff
Yes.
on code enforcement.
Mm-hmm.
And let's go to Moriarty.
Yes.
The residents there will not, or would not, I can't speak recently, would not, some of them would not walk down the street past this house to the park. This was a problem. But what are you looking from us as a council to do leading up to that point? Do we want to have our police officers serve process on them? Because there was a hearing about a year ago where they said that they didn't get any notice, and we asked where they wanted us to mail the notice, and it was to the address that the notice was sent to. We need to give you clear direction as to what we would like to see from you when you present these, be it serving process from our sheriff's or from our police department, or even the sheriff's department if we want an outside service or a private process server. But you can prove notice. Maybe that's what we would like up here. I'm not sure. What, when you get to the city council, are we looking from you?
Sure.
Do we want fact witnesses? Do we want photographic evidence where you taped it to the door? And then the corollary is, since we've put these rules in place, what do you expect from us? If you have done what we've asked you to do, are we going to stick to our rules and our fines and our fees? And these are private property rights. So, if we ask you to do X, Y, and Z, then what are you looking from us in return? And so that's what I'm hoping that we can get to today, is maybe get some more of those notices policies down where we do want that extra step. Instead of a certified letter, maybe one of our police officers posting notice or attesting to service and who they served at the time, the date, etc. But I'm hoping that when we leave here today, we can all commit to ourselves that if staff follows these procedures, then we will stick to enforcing our rules, because that's how we get to our
Chris, do you want to?
2.0.
Yeah, so I know we've covered that.
So it would have to be in addition to the certified mail has to be done for statute. But if you all want to add a second layer, then obviously y'all have the discretion to either amend the ordinances just to put in the procedure that either a process server, or if you want to use an officer. I do know in order for that to count as like a process, like the sheriff's department type of process, there has to be some sort of, I think, permission either worked out with the sheriff's office or with the First Judicial Circuit chief judge. I'd have to look into that for you. But if y'all want to go with a more onerous, or not onerous, but a more thorough type of service, then there's something that says you can't do that.
And I'm not suggesting we bypass the statute. Maybe we add an extra layer that is an internal requirement. And it may not be just one time, it may be multiple times throughout the process. But when we get here and you're asking us to uphold the rules we've given you, then you need to know what we're going to ask for. And if it's multiple notices, if it's once a month, if it's once every 6 months, but when they say they didn't know about this issue, then, maybe is that the number one complaint we're getting is notice? Or
I mean, honestly, for the 1,000 or so cases we are, opening each year, it's the one or two that that get to this stage at council that are the ones that I can almost promise every time they get here, they're just going to say, I didn't know about it. It's 99.9% go through the process without issue. They show, if they have to go to a hearing, go to the magistrate or the board, they're there, they're aware of it. It's a very minuscule percentage that actually get to the council, and almost 9 out of 10 times they're saying they didn't know about any of this until it got there, even though they in many cases have actually been at the hearing. But they've been in front of the board, they've tried to make their case. They still will come up here and say that, unfortunately. I know for 137 Moriarty specifically, in that current process that we've been working through for a few years, we did have a private process server that we worked with Mr. Burns on to make sure that owner specifically, we've been in contact with him. He's actually made great strides to clean up the property. I don't know if anyone's been by there just recently, but it's almost all cleaned up. It really is as of this week. So, but that one, we did do a whole bunch of extra steps of notice on there, in addition to various, phone calls with him, and, it worked just fine. If you want to do that for all, we certainly can. I don't know that it's needed for the vast majority, maybe the ones that escalate, up through the process. Typically now, we go to the magistrate or the board for an order 1. which sets a deadline to come into compliance. If they don't come into compliance by that deadline, they'll be sent a notice of hearing for an order 2 that they'll go back in front of the magistrate or the board. And if it goes through order 2, that's when the running fines would start. And then they're just, as far as that process, it's completed. The fines are going to run until they clean it up and come in compliance. I don't know if we want to set it to do it for an order 2, or even if it progresses past an order 2, that's when it comes in front of the council. For the very small percentage that would either be a nuisance abatement or a foreclosure action, maybe we do that extra step of serving it differently for an action in front of the council. So, some options there, but I'd say in general, we do so many of these, and there's dozens of cases each year going through the boards, and the vast majority we don't hear that from. It's really the ones that come here.
Mr. Jeter. I would 100% support that, what Meade said. I think we said that a few meetings ago. Like when you get a subpoena, you can't come in here and say, I didn't see it, I didn't have it. So
Exactly.
I think what you said, a hybrid of, there's thousands of cases. You probably get 800 or 900 in compliance without us ever seeing or hearing about them. So
Exactly.
that 10% that does go that far, then we go that extra step. That way when they do come in here, we have that photograph saying, you can't say you didn't know, because that's 100%. When it goes back to the magistrate or the board, what works best for you? Obviously, you have times when quorum's not hit, this and that, but the magistrate is much more beneficial for you to get things done. Let me kind of say that a few
It
minutes
has
ago.
been. I mean, from my staff side, they've they felt it's definitely just been a quicker, easier process. I mean, time of the hearing, and said we like to stick in just the facts of the cases. We try to take emotion out of it, and we understand that citizens, it's they have emotion. It's their neighbors, it's their community, and it can be tough on some of these cases. In that aspect too.
I'm with Councilman Meade. I want to do whatever we can up here to support you to get as many as we can in compliant. I mean, I think we got an email on some today, trash on a lot and renting pontoons. I mean, the list goes on forever, all of our codes of compliance that aren't met, but we need to get them all,
For sure.
As you said, 2.0. Let's get the 2.0 as fast as we can. So I'm with Meade. How can we help you do this faster?
Well, we could put a policy together to look at how we can add to that notice, that sort of notice. Maybe at that later stage of the process there. We can look at it and discuss with staff, say maybe at the order 2 stage when it's coming back to actually assess those running fines, or potentially at a nuisance abatement process.
My only recommendation on that would be if you're actually going to change the process up, I would codify it in the
Yes.
ordinance, and because there already is a pretty detailed process for code enforcement. So I would say the notice also has to include a process server or a certain state. That way, if they raise a legal challenge on appeal, then you can say you comply with the actual ordinance, not a policy.
Yes, sir.
I would say a couple things too. I know this is also the next slide in your presentation, so I'll reserve my thoughts on all that. But as for the code board versus the magistrate, I know that when we first started discussing this, as you brought up in 2021, the idea was that the magistrate, as you said, would be available more frequently, right? So you have a thing that really needs to be in front of either the code board or the magistrate. We need to get that going. Your people need to move forward in the process, and the magistrate is available on a much shorter notice. Is that correct?
Yes.
So I think that when we had first talked about it, we always kind of envisioned, at least the council at that time, and obviously this is a different board, but we had envisioned, still using both and kind of having a hybrid process, because there's many things, as we've just discussed and learned up here, that aren't huge, issues that need to be solved right now, this very second. At the same time, we're still getting that citizen input, that, feedback, that involvement in the process from our citizens. So if we had both, that doesn't harm anything, correct?
Correct.
I mean, and that's really kind of the way that we started with this process, and obviously it's been interrupted several times. COVID, Ms. Kopp being hired as the city attorney instead of the special magistrate. And now that we find ourselves here in 2024 with a special magistrate, there's nothing to say that we can't say, hey, both is actually the best solution. Does that make sense to you?
It does,
I mean,
absolutely.
and that would work for your needs?
For sure. I'll say the thing that collectively we'll just have to determine is, are there certain types of cases we want to go to one versus the other, or is it just a time-sensitive nature of something that we want to get in front of the magistrate quicker than the board?
Sure.
We're certainly open to, figuring that out.
Yeah, and as you said too, we're not hearing about the majority of these cases. You know, we didn't hear about, for example, when the guy who lives at my house got a notice that said the bush is overgrown on the sidewalk. And what I did was go out with the hedge trimmer and trim the bush back that was over on the sidewalk. And I never heard anything else about it again. I didn't appear before a magistrate or, have anything to do with anything. I just trimmed the hedge back. So, as you said, if you have 1,000 violations in a year, I mean, I've been on the city council now for 7 years. I think I've seen 3, maybe 4 in that amount of time. So before we get like too involved in saying like, let's make sure every single time we're sending out certified mail or sending a police officer over there, let's make sure that we're putting those guardrails on what violations we're doing that for and what step in the process we're using that. But anyway, I'll save the rest of my comments for that. Thank you, sir.
Mr. Berry?
I've heard from several residents in Fort Walton asking for the code enforcement board to be brought back. And I would like to entertain that idea. Matter of fact, I would like to vote on that.
Sure. I mean, it's still active. I think the direction there, and certainly welcome to vote on it, is for Kim to know whether or not to advertise for the vacancies. Currently, we're down to 4 members on that board, which is bare minimum of quorum, so we certainly need to fill some seats on there. But like Kim said, we haven't advertised them just because we knew we were going to have this discussion, and we didn't want to waste anybody's time or efforts if it wasn't needed. So we can definitely get those advertised and get it back active.
I would like to see that because the citizens, and this is who I represent, the residents and the city here. But I'm hearing a lot from all over. How come we don't have the code enforcement board anymore? We have that other one, the LPA, and we get a lot of business that way. And we're not paying the board to be on there. We're getting an input from residents up here. So I would like to see the code enforcement board come back. And then the cases that they're not able to decide upon, hand to the magistrate, say, hey, this is what we need help on.
I like that idea, Gloria.
So do I need to make a motion?
Yeah, you need to wait to the actual city council, but you can't make a motion.
Okay. Well then,
Sure.
at 6 o'clock.
Thank you. Mr. Smith?
A couple of questions. First one is do you know the percentage of cases that move from an order 1 to an order 2?
I do not offhand.
Extremely low.
Okay.
What was that? I'm sorry?
Just wondering how many cases move from an order 1 to an order 2. Next question I have is, do you know kind of around our state what the makeup is of this process and the other jurisdictions? Are people using code boards? Are they using magistrates? Are they using a hybrid of both of them? What are they doing?
Right. I know actually Mr. Burns did some research on that recently, looking at the Panhandle here, and I believe it was out of 27 jurisdictions, there were 2 code boards in effect, and it was City of Fort Walton Beach and Okaloosa County, and that was from Escambia County to Bay County, that entire region here. There were 2 code boards in effect.
Now, that does not include like Laurel Hill, Century, Jay, Paxton, the extremely small cities. They don't have their own code enforcement board because they're so tiny that their city council does everything, like their own LPA and all that as well too. So, but that's only a few of the 27 that he mentioned. So, and Fort Walton's the only hybrid still, as with the magistrate and code board. Now my search stopped at the Bay County line. I didn't move into South Florida, but I know South Florida is where the whole special magistrate thing kind of came from. Most Central Florida and South Florida jurisdictions use special magistrates.
And why is that?
I would say, and I'm biased in my answer here, so I would say because they're more efficient if you take cost out of the equation. And I know I talked to you about this earlier, and I said if you ignore the fact that you are paying a magistrate to be there, then the magistrate will apply the law impartially more often than not, and not rule by applause, which is what you call it when a code board decides that they want to throw someone a break and ignore the law. Now, I don't think that necessarily happens a lot, but I think magistrates are more consistent. And I know there's a thought that maybe the magistrates don't actually ever rule against the cities, but in my experience, especially when I got first hired out in Destin in 2016, they had their first set of magistrate hearings. That magistrate for the first year ruled against the city more times than he ruled for the citizens. And it taught the code enforcement department there to do a better job. And as a side, the code enforcement department here does a much better job than Destin's did back in 2016. So I'm not saying they're like that, but I've never seen a special magistrate favor one side or the other. They're impartial and they do a good job of applying the law and not really getting caught up on what's not actually relevant to an evidentiary hearing. And so that's my biased answer why I think it's fair. Because I am an attorney and a former judge, so I'm always going to say a magistrate's better.
Mr. Walker?
Travis, you done?
Yes.
Just you, Mr. Burns, mentioned the process, that there's quite an extensive, detailed process, and that's kind of where my mind goes to, because I dealt with code enforcement before, and a code enforcement inspector shows up to the home. He or she received a complaint, right? It came in through the means, and then the code enforcement guy is sent out and he does an inspection. He takes a picture, confirms it is or isn't, and then it is there, and then he comes back, and then what? Is that described in the process you're talking about? Because the couple that come to my mind, the little house over here where I think they hadn't lived in it in forever, and the daughter or the son was in Texas or something, so a letter was sent to here to the resident, but their address and the tax records were in Texas or some variation thereof. So it's like, maybe if we're talking about a police officer going out there, and where can we find that detailed process that you described that it's already in existence? We'd have to, is it in an ordinance that
There's an ordinance, there's a process, and it's not exactly one section. I'll get the number for you in a second, because I actually do have that written down here, but to save time, it is in the code. Now you're getting into, if it's pre-notice, I don't know if there's actually something that spells out what Burt's department does, like in their investigative phase, but there is a process once a notice is sent out, then how it proceeds from that point forward.
Right, he posted on the house, or if he sees them there, he delivers, hey, here's a violation kind of thing. And then there's a follow-up process, right? And if it all works out, then we never hear from them, the magistrate doesn't, then that's done. But those couple, whether, those forms that were being sent to one in particular, I remember, and her complaint was that she complied with what was written on the letter. She called that number or sent that email, it wasn't responded to. So that's kind of down into the really details of, could this have been avoided? From what little I know, it could have been avoided going to the magistrate at that time. And fortunately, like what you said, when she did get before the magistrate was something, I think, and nothing, again, it was just from the code enforcement, the magistrate said, well, why don't you just cover it or hide it? And the citizen was like, I can do that? So yeah, well, all of the things that were provided before as an option to solve the violation did not include putting it behind the fence, which Moriarty's doing now, which building is it an 8-foot wrapped fence so that we can't see back there?
Basically a screened area, yes.
Right, so, that process of, getting to see all of the forms and notices that you guys sent, I'd love to look at it and see if we could, if we're gonna be putting in that police officer service, that we also mail not only to the resident address, but the one that's listed in the tax record, if it's different. You know what I mean? Because a lot of people are caring for their parents' homes that they left here and stuff, and tenants get it and they toss it, or it's vacant and they don't get it, and then we go, hey, we did what we had to do, which was send a certified letter mail to the house.
We send it to the address on the property appraiser's site, which is what's required in the statute.
The state statute does require the certified mail to be sent to the
ones-
address that's on file with the tax collector as the actual registered address.
Gotcha.
Yeah, what we do, that's required, but what we typically do too is send it to the occupant as well as, so we actually send 2 notices out, one to the address on the tax collector's website, and then a second to the occupant too, so we try to catch it from both sides.
Great, yeah, if you could send us the stuff to look at least I would be interested in seeing the, thank you.
I would like, also, Mr. Burns, I would also like a copy of what you sent.
I'll email it to the entire council.
Thank you.
Thank you, sir. Other questions, comments from council? Respect to you.
Okay, moving on. Some of this is coming up, we probably have discussed already, but I'll kind of go through some of that. Actually, the next slide is discussing the standard code enforcement process. I'm not expecting everyone to look at that tiny little picture with a whole bunch of colors on it, boxes, but that is the standard code enforcement process for one case. We do have flow charts. We do have some process charts to chart out this stuff that we've developed over the years. I'd be happy to send that in a larger size that you can actually see, but really what that illustrates is each box is a step in the process for any standard code enforcement case that my team deals with each day. The bullet points on here kind of go through the process, and kind of Councilman Walker talked about some of that initial process and how you kick off that. This really runs down through it, that once we identify a violation, we do provide a courtesy notice, either in writing or verbally, to the violator with a time frame to comply, typically 10 days, but can be different, trying to provide a reasonable amount of time to comply. If they're not complied within that, then they would receive a notice of violation for a deadline to comply. Statute does require reasonable amounts of time to comply, unless it's a public safety type welfare issue. From there, if it's not in compliance, we send the mail. This is where you're throughout this process, you're talking certified mail and posting on properties and all. But we send a notice of hearing to go for the first Order 1 hearing. It would go in front of the Order 1, in front of the board or magistrate for the Order 1, and then they'd be given a deadline to comply. If they don't comply by that date, it goes back. There's a second notice of hearing too that's provided, certified mail again, and then they would go back for the Order 2 hearing in front of the board or magistrate, which if they're not in compliance by that deadline, typically that's when they would have the running fines start, and that's where the lien is recorded. Running fines begin. This flow chart basically sums up that process there. And some things to note, and we talked about some of these fines and violations. Just a quick note in there is that the fine amounts are all specified in the Florida statute. For first violation, a violator fine can be up to $250 a day, and for repeat violations, it's up to $500 a day. If it's an irreparable or reversible violation, something that can't be undone, it can have a $5,000 fine assessed on it. So that kind of sums up. It's all we really. Florida Statute 162 Part 1 goes into the standard code enforcement process. And some of what we talked about here with providing extra notices and all is great. That's actually in some of what we try to do already. Per statute, the courtesy notice is not required. It actually, you can start adding notice of hearing with a reasonable amount of time to comply, but we do give an additional notice prior to that. And then the Order 1 and Order 2, we've checked with different jurisdictions around this area and throughout the state. Most that we have found do a similar process to this. However, we could actually combine those two hearings for the Order 1 and Order 2 into one hearing if we so choose, but it's been practice at the city here for many, many years to have two separate hearings to just give more process, more due process, and more time to come in compliance. So our process, it's pretty lengthy. I said there really are about 2 steps that could be removed, but we all do this with additional notices for each just to give some more time to comply. So the other process on that Florida statute identifies are code citations. Something you may be aware of, we have had some items in front of the council a few years ago to put in place the process to allow for code citations to be issued. It's pretty specific in the statute how the process is to work. It's something that we do have in place now from our side on the Code Enforcement Division. We've only dealt with them very little for our, as we've gotten into it, we've developed a process, we have everything in place for it, but we have found that the standard process works better for most private property violations that we deal with day in, day out. The code citations, I know the police department has worked and utilized more so than us. That's something that I know they work with. You can issue right to a violator, someone on the street, you can give them a citation right there. So pros and cons to both, and so this is another process that we do have in place as well, so we do utilize and share with the police department as well throughout that process that we developed there.
I have a question.
Oh. Go ahead, Mr. Berry.
With the violations, how does this deal with homes that have businesses that the state says that they can have a business there,
Yes.
and their litter in their yards of their business, plus multiple vehicles in their yards and on the street. And if I remember correctly, the state said, correct me if I'm wrong, that they were not to be parking their vehicles on the street, but to have all their equipment and their generators that go on 24 hours a day,
So-
making noise and things like that.
So all of those issues we can still cite. We're fortunate, the statute, although it does restrict a lot of what we can and can't regulate when it comes to home-based businesses. One of the provisions within the statute, within the state law, is that it can't change the residential character of the property. So when it starts looking like something else, when a generator's going, that's a violation of our noise ordinance. If you have parking, you have to show that you have basically sufficient parking on the property to meet the code requirements. So if you don't, when you park on the street, that can be code violation, depending how it's functioning there, signage, equipment, those can be code violations across the board. There's BTR requirements that home-based businesses have to have BTRs, but if it's a home-based business, they also have to have BTR. However, if they don't meet all those criteria, then they can still be a violation. So we are still able to cite those. That's actually what like delivered vessels that I'll be getting to as I get through the presentation here. Delivered vessels, because of those changed residential character of the property, they're not allowed. So we are still allowed to cite those.
Well, how often are the people driving around our city looking and inspecting the properties that I just mentioned?
Sure. I'd say our 3 inspectors are out there daily. I don't know if you have anything to add, Bert, but
We're daily looking for that kind of stuff, and if we can identify it, confirm if it's commercial activity, we'll send them a courtesy letter, and usually they correct it. But often they reoccur. So
I have a list.
send them our way for sure, because we can cite those. We do.
Well, I drive throughout the city, with my little red cap, and, well, isn't that what I'm supposed to do? Is to, and I have a list.
Yeah. Oh yeah, and that's what I always say. We always try to see it. Obviously, myself or even other staff, when, in my department, we'll be driving down the street and see something that's a code violation. I'll send it right over to Bert or the guys, depending on whose zone it is, and say, hey, go inspect this property. So turn it in. We get it from every direction we can. So.
Well, I've sent some to you, but I'm going to start.
Sure, absolutely.
Sending more.
Okay.
Because there's abuse,
Yeah.
truly abuse.
Yeah. We'll take it.
Mr. Alberto.
Thank you. Mr. Paccetti, I want to ask these questions because I think it's really important to try to form this process. If we're going to take any kind of action to amend this, I want to really understand exactly what we're doing. The violations identified, right, back to your previous slide of the process overview, actually 2 ago. You've identified a violation, so then a courtesy notice is sent out. For instance, that's what I got in the mail. Bush is overgrown onto the sidewalk. Somebody probably walked by and said, hey, this bush is a little close to the sidewalk for my liking. Fair enough. Send it into the code enforcement. They see it. I get a letter in the mail, right? That's the first thing. So I trim the bush. That's the end of it. If I didn't, then I get a notice of violation. Is that correct?
Yes, sir.
Okay, so I don't comply in that time frame. Now I've got a notice of violation. That means what? Do I start paying money at this point?
No, sir. So what that will have, that'll give you the specific violation. So that we'll cite the violation in there. We'll give you.
So you got 15 days to get out and trim this
bush. You got
bush.
15 days to do it.
Okay.
If you don't, we'll re-inspect on that deadline.
Okay.
If it's not being corrected by then, we will then send a notice of hearing.
So the notice of hearing, is that then the first certified piece of mail that comes to me?
Notice of violation.
No, notice of violation is certified also.
Yes.
Okay, so
Yes.
basically you're giving me the courtesy notice to say like, hey, we're trying to be cool, just trim
That's-
this bush.
yeah, that's
And you don't have to do that by state statute.
Correct. That's a
Gotcha.
violation.
So then once I don't do that, now the certified mail has already started. So you've given me now 15 days, I don't do it, notice of hearing now comes, at the day of the inspection, plus however long it takes for me to get that piece of mail, so it could be 20, 25 days later. Now I've got a second piece of certified mail delivered to my house that says, hey, you gotta now show up to either a code board hearing or a special magistrate hearing. Okay, so say now the bush is getting really wild, it's still all the way out there over the sidewalk, I'm not paying any attention, I didn't open any of this, I don't care. I'm a derelict, I'm not paying attention. So now I get another notice, like I don't show up to this hearing, the hearing goes on. Hey, he's not here, now we gotta send him another certified piece of mail.
Yes.
So where in this process would you say, because as you said earlier, the majority of people get the courtesy notice, they fix the problem, and now it's done, right? And then probably the second biggest majority of people is, I get the notice of violation, now I fix the problem, and now it's done, right? So now we've knocked off a ton of people right there. But now we've escalated the situation, so at what point in here do we need to send a process server? And I know you'd probably say, hey man, we got all these processes already. But if we were looking for even one additional step in this, so that at any point during this thing, we felt as a board, as a city, that we were being completely fair to everybody, that we made 100% certain that we were making contact with whoever was in violation. Would it be between the notice of violation? Would it be between hearing 1 and hearing 2? Would it be after hearing 2? Where, in your opinion, as somebody who runs this department and has been involved in this for a long time, where would you think that would be the best place?
Chris,
Yeah.
do you mind?
Yeah, sure.
So you really have to look at it from the perspective, what's the judge who's going to be handling the appeal going to do, who's going to overturn it. And so you would want to probably make sure the notice, really the matter becomes final after that order 2, because that order 2 is what we filed in the Woods County Public Records and create a lien on their house. So you would want to make sure that individual had notice of that second hearing by the additional level process. So I would recommend that you do the process server with the notice of that second order 2 hearing, because if that individual then comes in front of the magistrate and says, I never received any notice of this, the magistrate's aware of it, and we'll make an adjudication as whether or not they believe them or not. And that would cure any notice issues. They might give, most likely, the current magistrates would probably give them an additional 90 days or something like that to comply. But from an appellate perspective, you're protecting yourself, because if the individual actually shows up and then doesn't assert certain offenses at that hearing, then they've waived them as well. So that's when I would recommend as your attorney.
And that would still, as an attorney speaking, that would still keep us in compliance with all the stuff from the state. That would not add any undue burden on our taxpayers, or I don't
know about that. I mean, that's your decision.
Well, I know, but these fees we are charging to the violator, obviously, as well. So what I'm saying is that we're still doing the process correctly. We're just adding an additional step in there that would really make everyone feel we've done everything humanly possible to make contact, to make sure that this person is aware that they are violating these codes and that they need to appear before this magistrate and they're being fined and all of those things. Right?
From the attorney perspective, yes. But I don't know if Chris has a different opinion.
I think that's reasonable.
Can I ask a question for Mr. Burns? If we were to add and make it a requirement for an additional service at that point, and say your owner's in Wyoming, and now you can't serve him because he's not here.
You can serve someone out of state. We can put the provision in that we'll follow the same rules that the Florida Rules of Civil Procedure require regarding out-of-state service. And so
I just didn't want to have us where now we're tied our hands, we can't move forward.
You need to probably
It's gonna
build
slow
in,
it down, obviously.
without getting to the nitty-gritty tonight, this workshop, we probably would need to build in an additional, if one of those is required, maybe an additional month, for their notice of hearings, it might take a few additional weeks to get them served through a process server in Wyoming.
Whatever the cost is for that, so I just didn't want to keep us,
Absolutely. No, that's why we're here, to have these kind of discussions, for sure. I would just like to close my portion of this just by saying that, I hope that we can get some of this information all back together, get it filtered through our city attorney, and then, come back to council with some sort of update to this ordinance, to this process of serving somebody the certified mail and all the violations, etc. I sincerely do appreciate that you guys go through a ton of steps. I know there's not enough of the code enforcement officers as it is. But at least this step is not on you and your department, as far as once you say, hey, go do that, you don't have to be the one that goes and does that. And that would satisfy at least me in saying that, hey, we did everything we possibly could as a city to make sure that you were aware of this as the violator. So thank you, Mayor.
Thank you, sir.
Mr. Mayor,
Mr. Walker.
I'm just sitting here listening and thinking about the cases that have been here before us. one recently that was probably the largest turnout I've been seated anyway was regarding the proposed moratorium on pontoon rentals. And I asked you that day how many were there, and I think you said 22 or thereabouts. And I said, well, how many are non-compliance? You said 19, and I think 16 of the 19 who were here, I asked them that specifically, and they said, no, I'm in compliance. They all thought they were in compliance. Is that a part of this process, or was that because that was business? I mean, you know, there was a proposal to stop a moratorium on those businesses, small businesses, and it was based on the premise that they were not in compliance with something. I don't even remember what they were, because I don't even know if I remember what the non-compliance was, but from that alleged non-compliance came a proposal to put a moratorium on it. Were those business owners, were they a part of this process?
No, they had not been cited yet through code enforcement. There's a lot of parts of that, and actually, my supervisor Tim is here, that really kind of lit up that charge on that, is that because there was that 2-year grace period to come into compliance with that livery vessel ordinance, those businesses, they had been involved in the planning process, the code creation process, you know, for those 2 years. We had, as we were coming to that deadline of September of last year, we had, because we knew that topic was coming up, we had not cited them yet through code enforcement at that time. So they hadn't started this process. They would have, you know, been noticed. They would have gone through that had we done it at that time. We had just been in contact with them through my planning department. So Tim himself had met with most of those businesses one-on-one prior to that date. And we were waiting because that was the end of the season. That's why I think that date was put in back then. It was the end of September. Figure, okay, their season's getting into all season. We can work with them over the winter, because what happens is, you know, those businesses that were out of compliance for that specifically, you know, if they were closing up, a lot of them were closing up for the winter. They weren't out of compliance because they weren't operating at that time. They were going to be out of compliance come March-ish, you know, timeframe, come spring. And so they hadn't been cited yet. Following that meeting, we did have another follow-up meeting with the delivery vessel operators group. Go through it all, and got with each of them. We talked to each of them, said, hey, meet with us one-on-one, go through it, and we'll work. And since that time, unfortunately, a lot of them are still not in compliance. We have a running list of a checklist of exactly what part of the ordinance they're not in compliance with. And they've all been cited through code enforcement now, and have started the actual formal process that we're here talking about tonight for the ones that are not in compliance.
Thank you.
Yes.
Mr. Mead?
That's my follow-up question to you that you've answered.
Yes.
If you know they're not in compliance, what are you doing? And it sounds like they're in the process.
They are. They're all have active code enforcement action on them for the ones that are not in compliance as of now.
So you're enforcing the
Yes.
ordinance we have in place?
Yes. Yes, yeah, we did actually, because the ordinance is pretty clear. I mean, it's almost like a checklist. We made it a checklist. We made a standard code enforcement courtesy notice that we can send out, tailored to each of them, saying, hey, because they've all applied for BTRs. Everyone that we're aware of, I believe there's 23 of them now. They've all applied for BTRs, but they don't meet all the requirements of the code. So we're citing them for the specific code requirements that they're missing at this time.
Mr. Mayor?
Yes, sir.
Just to kind of continue with that same conversation, I'm a big fan of checklist.
Yep.
So the pontoon boat conversation, what does that look like? The ones that are out of compliance, they get the certified mail.
Yes.
Then what type of level of service happens after that? Do we just send the certified mail and hope they respond and change their behavior? What is that checklist?
Yep, so, all these businesses we've been in contact with through the planning side already, the ones that were cited, they do start with that courtesy notice. We put, I don't have a big copy of it, but this is the spreadsheet we've got tracking all of them, color-coded with little check boxes, and we've gone through, and that's where we're tracking it, with the status of it, verifying if they meet or don't meet. And as I said, most of these, if not every one, we have actually talked to individually. It ranges from site plans, storage plans, submerged land leases, those
Correct.
types of things.
Different
It's
things
just
that are out of
different things,
compliance.
and so we've been engaging with all of them.
Awesome.
But, it's just, for one reason or another, they just haven't done it yet.
And that's the part I was kind of wanting to impress on.
Yes.
and you answered it, after the certified letter has been sent, it sounds like you have engaged, or they've engaged with the city, and there's a correspondence of figuring out what they gotta do to be compliant.
Yes.
Have there been any that have not responded to the letter?
To know.
I'm not aware yet. Richie's handling most of them.
Since those letters have gone out, only one company has reached out to me.
And that's kind of where I'm getting to. You know, we got the certified letter, we meet the statutory requirement before we get back in here, a room full of small businesses that say they didn't.
And a lot of these are.
Like we said, when we started this workshop, a lot of them claim they didn't hear anything, they didn't get anything, and all that stuff. I would just like to, I know our team is doing amazing at trying to bring this new ordinance into compliance and all those things, but the engagement between the certified letter and the actual action being taken to try to improve the code.
Yeah, absolutely. And a lot of them, you know, they check, you know, a lot of the boxes, you know, maybe half, maybe more, you know, all but one. And that's where we're just trying to say, hey, we need, you know, these items right here. And that's where we've told them specifically what they're missing at this point. And, you know, if they don't comply, then they'll be going in front of the board of the magistrate. You know, in the future here, we hope they can comply. And that's where, I said, I know we've been in contact, you know, with them. We're kind of tackling it from the two sides here. We've got planning and code, because they're working together on this, you know, sharing the spreadsheet and the statuses back and forth.
Thanks, Chris.
Mr. Mead.
So if I decide to run a pontoon rental out of my house in a residential neighborhood, what would you, how could you immediately stop me from doing that? Would it be from a friendly meeting saying we're going to start fining you, or?
I mean, that's what typically, yes. I mean, if we see it, I know we've dealt with a few of them here, but if we see it, yeah, we're going to start with a code notice and say, hey, you've got, you know, typically, you know, unless we have to provide a reasonable amount of time to comply. So typically, that's going to be a 10-day compliance period that they've got to cease that action because it's just not allowed use in that case. And residential is not allowed, so they have to stop it within that deadline.
And then you'll start a code case if I refuse.
The code case starts, technically we do open the case with that first notice. The case is created on that date, that first notice, that we identify it. You know, the challenges, and Mr. was aware of them some, is that if we can't see it, that's where it unfortunately gets really difficult, is that we have to put our eyes on it or have a witness providing sworn testimony to be able to start that case. So if we can get, you know, if we can see it, we get pictures. We've got pictures on some of these, and that is evidence, and we can take that and get through that process. But you know, every case is unique, so it's a little tough. But that it's not allowed. So,
but if I had a sign, and you know,
yes.
And so the follow-up question to that is, with that clear example of a case that's in violation, are we taking that same step for all these other businesses who are not following our ordinance? Is it the same?
It is.
Same steps that we're taking?
It is.
So we've notified them, we've started a case,
yes.
And we're moving forward with
yes.
hearing number 1 or hearing number 2, as the case may be.
Yes.
Okay.
Mr. Mayor?
Yes, sir.
Yeah, I don't know who you want to direct this to, I mean, Chris, the city attorney, or city police, but with that same kind of scope, you know, we have, let's say, this area with water access, you know, we've identified 15 or 20 locations. Like you said, if you can't see them, you don't know they're going on, but once they're identified, where we might have a different subject of, let's say, front yards or things like that, they're out of compliance. Well, we follow the same process. But are there any areas, municipalities, or things in the south where, whether we need to bake it in through ordinance, where we can get, you know, whether it's public safety involved, or there's some higher level of needs, whether it's the pontoons being run out of people's backyards, or fill in the blank if the council or the community or staff thinks there's a certain issue or subject that has a need for greater attention.
Sure.
And we're trying to change the behavior, and we're following the process, the same process, no matter what the subject is, whether it's pontoon boat rentals out on the residential unit, or, you know, the grass is too long. We're following the same process, certified letter. But if we want to get that attention quicker, and we want to change that behavior quicker, what are some things that we could do?
Sure. Say, you know, there are certain provisions in the statute that allow us to kind of expedite that process. I'll say on the river vessels specifically, and the boats, we've been even working with Fish and Wildlife to help get evidence and shut them down from that side if they are out of compliance with state law. And so Fish and Wildlife regulates the river vessels. There's some challenge there too, because there's what we call delivery vessels, and then there's what they call bareboat charters. Bareboat charters are basically pontoon boats that are captained. and Fish and Wildlife does not regulate or touch that, that falls to the jurisdiction of the Coast Guard. So we've been trying to, work those angles. As far as we're concerned, neither of them are allowed use in residential areas. So if they get evidence that they're operating either, it helps us. And one of those in town here, they just about 2 weeks ago now, they did catch a boat. They tied it back to a residential address, but they found that it was a bareboat charter, which means Fish and Wildlife's adamant they don't touch it. So we are working with them on it too. I don't know if you have anything else to add as far as process.
My experience from Destin, and they enacted this about 6 months after I left as their city attorney in late 18, but we've been in the process of discussing it. I do know they call it medallions now. It's not really medallions, but what they did was they decided to basically, all the livery businesses that were still active at that one point in time, they kind of gave them like the right to operate, as long as they weren't doing it like behind someone's house or something like that. But they basically created an incentive for the industry to regulate itself. And that's one of the most efficient things that happens now, because if one of those authorized livery businesses sees an unauthorized livery, they turn them in immediately to the city, or they'll go tell them, kind of like they'll self-regulate themselves by saying, you need to shut down or else, which is, self-regulation in itself. But that's been one of the most effective things, I would say, is, now I'm not telling you what to do that, it's just, you're spitballing right now, and that's an idea.
And I know Ms. Kopp has been working on some updates to the litter vessel ordinance that Tim and myself have been involved with her on too, looking at some registration processes and all too similar problems with that.
I guess, the process of the gold medallion is helpful, but I guess what I'm getting to, so the FWC example, we got an email today, like Bryce was mentioning, that allegedly someone at 177 Bill Parkway is running a business out of the backyard. The FWC shows up and says, hey, we're out. We sent a certified letter. You know what I mean? Then that behavior may still be going on, or it may not be going on. Do we see much of the behaviors continue after our staff has addressed those pontoon boat rentals running out of their backyards? Or are some making the stance of, you know what, city, y'all talk to my attorney, we're going to keep doing what we're doing until, I guess that's kind of what I'm getting to. I know we're diving in the weeds a little bit, but this is
for sure. Yeah, no, it's a good question.
But that's what they're doing. That's why we have. That's why. How many code cases do we have for them not following the rules?
So we've got still about 18 or so.
So that's what they're doing.
Yeah, I mean that's.
Well, that's the ones that are applied for BTR.
Those are for BTR. Yeah, those are not.
Actively working in the backyard. There's only 2 of those right now.
I'm just talking about there's still all that many people that aren't complying with the rules that we have in place, and they're still operating.
Yeah, that's why I was kind of asking, what can we do to get a different level of intervention besides this a round 2 of a certified letter?
There's another option. It's not as conventional in the code process, but nothing stops us from running parallel processes. So we could go out there and write them a civil citation and open a notice case. So if we get a call out saying whoever's renting a pontoon behind their house, we can go out there, if we get cause for the rental, we can warn them the first time, we go out there the second time, we can write a civil citation. When we write the civil citation, we can also start the notice case. The 2 can run in parallel. We get a third call go out there. We can write a second civil citation. We can write a third civil citation. We can write a 4th civil citation. We can write a civil citation for each new violation that we go out to. In the meantime, in the background, the notice case can run. And by running the notice case in the background, at the ultimate step after the Code 2 hearing, you could actually then maybe get a court order, you could try some other injunction against the homeowner or something else, if you had somebody that basically just stuck their middle finger up at you and said, the hell with it. So, but I mean, there are other solutions that can go to it. It's just how aggressive we want to be in the solution and what do we want to do about it. But nothing stops you from running parallel processes with civil citations and notices at the same time.
My recommendation would be if you have law enforcement willing to do that for you, you explore that, because that was always the issue out in Destin. We had a contract with the sheriff's office, and it was hard to get them to actually do something like that. So if the PD's willing to do that, then that's something you should do.
And we write civil citations right now, so it's not a stretch for us to write a few more civil citations.
Question as it relates to those civil citations, because I think that there's different ways that you can do it. And I don't know if our code provides for this currently, and it's interesting that you go around some of these boat ramps and you see their sign that says, hey, first violation's $250, second violations, whatever, third violations, whatever. That's per violator. So if you go on a livery boat to rent the boat, you at that point in time are a violator, so they can cite the people renting the boats. Not only can they cite the operator. So I guess my question is if we do have habitual offenders that we know that are, giving us the finger, I guess, whatnot, would that be a tool that we could use? Because I promise you this, the second that you start citing the people renting, that business is, their reviews are going to go to the floor, and that will solve that problem pretty quick.
I mean, if we can construct a code, I don't know what that code would look like, because I don't think our current code allows for that, but if we could construct a code that would allow for that, we could, because it comes to the cost of doing business. And I think one of the questions, and I think it was asked by Councilman Meade, was what can the city council do to improve the process? And I can tell you from researching city codes from across the state and researching cities across the state, the difference between codes is minuscule. You'll see one code that says 8-inch grass, one that says 9-inch grass. Almost every city code is templated and cookie cutter. The difference is the level of enforcement and follow-through. The cities that have less blight are the cities that enforce and follow through on their code. They're the cities that don't add extra hurdles to it. When I heard some of the discussion going about notices, most of the discussions that have come in here about notices, and some of the more frequent ones, were all because they didn't change their homestead. They wanted that notice to go to the property still instead of the current resident that they were living at, and if they were to update their records with the tax collector, they would have got those notices. That was one of the big issues that we had that at 44 Cape, I think. We had it on Robinwood. Some of the biggest violators of the properties are the ones that have moved out of the property, are now absentee landlords, and have not changed their homestead. And we should not have to go and do an extra process to cater to people that have not changed their homestead. And I don't know if we do it here or not, Chris. I've seen in other cities where they do the certified letter, but then they take a picture where they post the property, and they use that picture then when they go in front of the special magistrate or the code board. One of the other things that was brought up, and I believe it was by you, Councilman Walker, was that nothing changes prior to or post the code board or special magistrate. That's an interchangeable piece. So all the notice requirements would be the same whether you went to a special magistrate or a code board. And then once that order is given, the same exact order is given by both the special magistrate or the code board. And I agree with our city attorney, and I'm a 100% fan of the special magistrate because I've seen in the city that I came from that converted from a code board to a special magistrate. As I've gone across the state and spoke at 3 different places on code enforcement, I can tell you the trend across the state is the special magistrate by far. And when you mentioned about the fines and excessive fines and everything else, whether you go to the code board or the special magistrate, that still comes back to the city council for fine mitigation. So no matter what route that takes, that fine mitigation would still come back in front of the city council, and the city council would still be able to review the fine that was issued in that case at the end of the day.
We do have a process just to clarify on that fine process, we do have a process through staff that would not have to come to council. It's only if they don't want to follow that process in the code ordinances, it would come from you all. So
it's kind of like it's 2-step really. What he's saying is if they're unhappy with staff's fine reduction, they can then come and ask y'all to further reduce it. Kind of. So y'all will always have the final say on the fine reduction. So.
Mayor? Oh, go ahead.
No. Mr. Meade, go ahead. I saw your hand first.
And I agree with what you say. I agree that we shouldn't be adding more steps to our process, but the last 2 code cases that came before the council, we backed off of what staff did. And so the plaza meter, I think your phrase was earlier, if you will, we didn't follow exactly the code. Instead, we listened to the people and the emotions in the story. So because they didn't change their homestead, or because they said they didn't get it, whether or not they did, I don't know. It's not up to me to decide, but we didn't strictly follow our rules in the last 2 cases. We backed off. And so that's why I suggested maybe we add something else if that's what we need for comfort level to be able to stand here and say, I know you say you didn't receive it, but this is what we've committed to. If we hear, we will stick to staff's proposal. And so when Mr. Rhodes goes to that house, he knows we're going to stand behind him because he's done X, Y, and Z.
Yeah, we do take the pictures like Chief even mentioned, posting on the door and taking pictures of windows and stuff.
Mr. Alabell.
So, thank you, Mayor. So, Chief, I think, and Mr. Fassetti, I think you've got a lot of our interest here with this enforcing and writing civil citations to these businesses that are really flaunting our code and, you know, all things considered, doing something that's very unsafe, which is renting boats, pontoon boats, jet skis, whatever, from their own residents to people that they have no idea, they're not responsible for, that et cetera, no insurance, all of the not, like we've put all of these processes in place for these livery businesses. And we've said, well, you got to have all of these different things. And we've now started enforcing these codes. And we did give them time to get into compliance. The biggest problem always seems to be the ones that we can't deal with because they're not a real business, right? And so when you stood up here and said we can write them civil citations, I think that you really hit on something that's pretty important that we can do as a city. As Mr. Burns said over there, you know, the city of Destin had contracted its police enforcement out. So they didn't have control of their own police department. So at that point, you can't ask them to enforce something. You have to hope that they will. With what we have here, we can say, hey, Chief, we really would like to see you enforce this because we've tried a lot of different avenues here to get these people in compliance. Obviously, they're, you know, short of sitting in people's neighborhoods flying drones over their fences, trying to see who's renting what or peeking through everybody's fence, and we don't want that. That's not what anybody wants, but we do want everybody that's on the water to be safe. And if there's people inside of our city that are contributing to it not being safe by renting out vessels to people from their neighborhood, violating our codes, etc., and we have an opportunity to use a great tool that we have, which is a local police department, to go enforce this, how do we get that to happen?
And I think you do it tonight by just telling us you want to get it done. We talk with the city manager, we work with code. I mean, we've written civil citations for dangerous intersection, we've written civil citations for other things, so it's not a hard thing for us to do with civil citations. Rufus right here, who's our community code compliance crime prevention officer, that's one of the things that we were going to task him with was the pontoon rentals and writing the civil citations. We were going to start at the boat ramps because that's really, the notice case, and like Chris said, has pros and cons. The notice case, you can get running fines, you get other enforcement mechanisms. The problem with a notice case, especially like at a boat ramp, to get that first and second order may be tricky because they're going to go there on a day and they're going to take a picture, there's going to be nobody renting them, and they're like, see, we're in compliance now. And then you just press the reset button and you go back through the 30 days, 60 day, 90 day, and the same thing at a residential house. You'll get somebody that's going to pack up for a few weeks, say we're in compliance, and then you get rinse and repeat, rinse and repeat, rinse and repeat. The civil citation will be written to them, and that's an escalating fine. I don't have it in front of me, but I believe the first one is 50, 100, it goes up to 300. So it keeps escalating as you go up as repeat violators. So hopefully at some point we get to a negative return on investment. The cost of doing business is no longer there. So we can start working on that, but the problem we're going to run into is a very similar problem that code runs into. It's sometimes difficult to enforce it from the public view. And we really need to be where we can view people getting on the boat, people renting the boat, pulling off the dock. And sometimes that's hard to do from the public sidewalk. Or if you don't have neighbors that are going to allow you access to their properties. So Chris has worked with FWC, and what gets tricky is that in the summertime, a lot of the marine resources get pulled towards the Crab Island and Destin. So it's harder to get the sheriff's office or FWC to come out and kind of hang out for a while and patrol the local area. So when you see them start loading up the pontoon and this and everything else, and you're like, wait a second, you don't live here. This is now a different person that stopped out here yesterday. Now we can start building that case to say there's cause to show that you're renting this pontoon out. The docks are a little bit easier because some of those we can go to. The ordinance said, in our ordinance, it talks about the pontoons have to be properly marked. So the marking of pontoons are easy with phone numbers, names, but sometimes it gets a little bit tougher with the rentals. I can tell you when I was down in North Miami, our big things were jet skis. So we would go out there, and with the jet ski, the Florida statute is a little bit different. In the jet ski statute, they actually have to demonstrate how to use the jet ski. So we could just sit right off the docks, and you would see somebody get on the jet ski, they wouldn't demonstrate how to use them, and it'd be in violation of the statute. We would cite them on a notice to appear for violation of the statute. The pontoon delivery statute doesn't require the onboard, but it does have other requirements for safety plan, notices. So if you see some people just walking up there on their coolers on and jumping off, and you stop them right off the dock, 90% of them are going to tell you the truth. They're going to say, hey, I just rented this from this guy Nick, he gave me a good price and everything else. Some will try to tell you, well, it's my cousin's pontoon and this and that. But you're really going to take that story so many times that you build up your cause to say, yeah, you don't have that many cousins. We know you're running out pontoons. But it takes some work sometimes to build some of these cases, and it takes resources on some of these aspects too. And it would really help, and the fireboat, in all honesty, would probably be too large for some of this stuff. A small vessel is really what's needed for code enforcement to look at conditions behind houses, enforcement of livery, jet ski violations, boating safety, and other stuff to go on. I know Travis is not a fan of that.
No, I am not at all. I think you can do it without a boat, and I can show you how to do it without a boat.
I'll say what we've done too, I hadn't brought up, but what we've done too, we actually was able to find someone that's a private investigator that actually has a boat that for a very low price will go out on the water, and he's helping us try and track him down in the waterway. So
I'll take you out on mine for free.
Hey, better price. So yeah. So
On a side note on that, I reached out to the town manager of Cinco Bayou, which me personally have witnessed a boat pulling off there that rented out, said you cannot do that here, there's no commercial activity. And he said, oh, just go launch it in Cinco. So this was last summer, but so they're developing ordinances too as well.
They got their signs up now.
Yeah, to take care of that, because they work on Plaza Jackson, Cinco, and vice versa. So the neighboring communities are working together as well.
Mayor, if I could just finish as well. I think my point here is that this is an important thing, and we want some sort of enforcement on it. And so whether that has to be like somebody's keeping a detailed record, you know, whether there's a specific person that's keeping these records, etc. We want to build these cases. We want to find and violate. We want to issue these code citations to these people that are running illegal businesses in our city, that are putting other people in danger, that are putting legitimate businesses in the question of city governments, of the public, etc. We want to enforce this to every way we possibly can. So if the police department can help code enforcement, that would be really, really ideal. Thank you, Mayor.
Thank you. Other comments?
I have a comment.
Yes, ma'am.
In addition to businesses in our state did a terrible thing, allowing businesses to go on like rentals, Airbnbs in our neighborhood. Airbnbs from hell, the 92-year-old woman said about 5 years ago.
No, it's going on right now. I mean,
Yeah,
they're
yeah.
there now.
Well,
With her.
I went to our legislators, you know, Congressman Maney, Senator Rudman, and on and on and on. They says, go to public safety. And thank you, Chief Beige, for the doing a sting or whatever it was, and we cut that Airbnb from we shut it down. And they were,
Not ours.
no. In my neighborhood. And so that's what I called. I got case numbers. They didn't want me to give case numbers. They didn't. I was tenacity, persistence, and this is what I suggest to the residents: to fight back, to get our codes, to get our neighborhoods back, to get make our neighborhoods nice, not trashy with all the businesses there. If this is what we have to do, then Chief Beige, that's what we'll do. You know.
I can tell you one of the things that it kind of got put on hold, but we can come back to it, especially if it's a big issue, was that we were looking at life safety things at the various Airbnbs and short-term rentals. And one of the things, and we were working on this with the previous city attorney, and then it kind of got pushed to the side, but if it's an issue that needs to be addressed again, we can get it with the fire department. There may be some fire codes and life safety things depending on the amount of occupants in the Airbnb. I forget the number, it was like over 16 or something. Some of the higher numbers may trigger some additional life safety things, and especially the ones like out in Garner Beach, that's a big house that they run out to, that they may be pushing some regulations.
I think there was a regulation that was passed that no more than 2 people to sleep per bedroom. Like if it's a 3-bedroom house, then you can have no more than 6 people occupying that Airbnb.
But I can send the stuff that we worked with the previous city attorney and the fire department to the new city attorney, and they can review it. Panama City or Panama City Beach had started enforcing some of the life safety codes for occupants over a certain number. From the police side, we have to look for something else, whether it's parking, whether it's drug activity, a criminal violation, and then we can take action if there's a unrelated criminal in violation at the property. But with the fire department, there are some life safety codes that may apply once they reach a certain occupancy. Now, for the ones that run out to 2 or 3 or 4 people, there's probably not a lot we can do besides enforcing existing city codes and state statutes. But some of the bigger ones may cross other lines that we can look into, and we'll send all that information to the new city attorney to get some guidance on that.
I appreciate that. Thank you very much. And I appreciate you helping with my neighborhood situation.
I did want to add on that too. We've had some real brief conversations with the city attorney too, because although the statute doesn't allow us to ban them or limit the frequency or duration of stays, we can actually permit them and we can still put criteria in place on them if the council so chooses. You know, we haven't gone forward to draft anything up, but we've had some initial couple minute conversations with Ms. Kopp. Let's talk about the other ways that you can tackle this. You know, looking at the occupancy, looking at some of those other negative impacts. If the council wants to go that route, we can certainly continue. Working with our
Mayor, if I may, just real quick, it's important for the staff in general, but most of, if all of you, if not 1 or 2, or you guys on a daily basis get emails from residents that get a code enforcement notification or whatever it may be, and they email city council, this is ridiculous, I can't believe I'm getting cited for this. Having the support from city councils, the staff here is loud and clear, enforce the code. And me as a city manager, director of the staff, let's do that. And I think you'll see that, we're going to continue to do that. And you guys will continue, and ladies will continue to get emails from the public that says, why am I getting code? This is ridiculous. And for us to hear council say we need to enforce the code, we will do that. But you guys get the emails and say, hey, we've directed staff to do that. It goes a long way with everybody.
And just one thing to keep in mind, I don't know if he's signed into law or not this year yet, but you can't do anonymous code enforcement complaints anymore. And they at least passed a law saying that this year, and I'm anticipating we'll sign that if he hasn't done so already, the governor. So if you do get one of those complaints, if you don't want to be the witness, ultimately, as the person turning them into code staff, as the person who made the complaint, you might want to just tell the people. I mean, forward it obviously to code staff, but you might want to tell the individual they need to also report it as well and let them know that they can't do it anonymously. That'll be helpful to them if they make a complaint.
Senate, I believe it was Senate Bill 60 a couple of years ago that actually put some of that in place already. So that's one of the challenges we've been doing for a couple of years now. Actually, is when that went into effect, because we followed it right off the bat. We updated our website and all, and that's where from people we get pushback saying I don't want to put my name out there, I don't want retaliation, I don't want these things. We do explain to them. We understand. Here's the statute. However, we're also out there on a daily basis. If we see it, we can still cite it. So that complaint may not have been initiated from an individual, but if we lay our eyes on it, we can still open a case on that.
And there's an exception for life safety issues.
Yes.
So if there's a life safety issue, sanitation issue, something that endangers the public, we can take those anonymous complaints. And as Chris said, even though we can't act on the information from the anonymous complaint, we can still patrol and we identify the issue ourselves and we become the complaint.
Thank you. Ms. Perry.
I've been here since 1970. Lived in the same house most of the time. And I've noticed a difference in our culture as far as the appearance of our yards. trash cans and garbage cans overflowing, home garbage out on the easement of the road, recycling overflowing, and it's constant. And they don't bring their trash cans and their garbage cans back off the easement back to where they need to be on the side of the house or wherever. I know that there's a lot of houses that AT&T, Live Oak Fiber and all that have hired a lot of people to stay in these houses and overflowing the yards with trucks. One in particular on Jet and Holmes, right there. That's a dangerous turn right there. And I've mentioned it to Chief Beige. And I've seen many almost near misses, and children too, because kids are coming home from school and going to school there also. But I've noticed a difference in our culture, the people that are renting the houses or even maybe own the homes, that they no longer take the pride. And you don't have to live in a castle. You know, you can live in a very modest home, but you can mow the lawn, you know, every other week, once a week. Bring the trash in. And I saw, there's a house that I saw, they had removed a wooden fence, and it filled up the whole easement of the front of the house, left for someone, I guess, the city to pick up trash. You know, or they're remodeling. I thought there was a code that if someone's doing this work, they need to take it to the dump. Can you answer how are we allowing this to happen? Or have you been hearing from the trash collectors or the whatever of seeing more and more?
I'll say I agree with you. I think it's something that we've talked about over the last few years. I talked with Bert and our code team, is that it just seems in general, you know, we don't know what it is with people, that they just have less pride or you know, transient or what the case may be. But it's something we've seen, you know, specifically regarding that. It is something we cite, and actually we've coordinated with our sanitation division. If it's something that we can pick up now, if it's certain construction debris material that we can, you know, that's where it comes into who's responsible for it, for the pickup. And something we see a lot of times is the tree branches, vegetation, all that too, because companies are supposed to, if a company comes in and trims landscaping your trees, they're supposed to remove it. It's in our ordinance. But yeah, that's where it comes into. It's private property owner do it. They can leave it there, but they're supposed to schedule for bulk pickups and things like that. So we cite that type of those types of issues regularly. It just then falls into whether it's falling back on a contractor that's supposed to remove it, or a homeowner that's scheduled with sanitation. Typically, our sanitation team will step up and just get it removed and coordinate with the owner or the tenant to if there's additional fees for extra pickups. But we do coordinate with them regularly, and we've seen there were some right here in the police department over there on the house just last month that there was a big tree cut down and it was just sitting blocking the sidewalk. We were dealing with that, and between us and Jerry Gunn and his team over Public Works with sanitation, they tried to make contact with them, but they couldn't make contact with the occupant or the owner there. So then we were working with code enforcement to see if we could get notice to them, and it took a few weeks, but it was all cleaned up, removed. But everything he said, yes, it's yes and yes. It's unfortunate that we are seeing him deal with a lot of that.
Well, those people are costing us, the other residents, our taxpayer money to do their work.
Sure.
So how can we prevent that? How can we?
I mean, we can always cite them.
I'll tell you what I do.
Yeah.
I make a code complaint. I made a complaint
That's
to
it.
Chris,
That's what we did.
and I followed up on a code complaint every single day when I went by there. I said, how come it's not cleaned up yet? And eventually got cleaned up, and I got sanitation involved. But it takes making that complaint. So if neighbors start saying, hey, there's violations on my street, Chris's staff is limited, we have one person. Our officers, from time to time, as they come by, they see major violations of the city code. They'll forward over to code enforcement. And I tell them they need to list me as a complaint, list me as a complaint. I'll be happy to come and complain about it at the hearing or somewhere else. But we need to intake this into the system. And we need to figure out what are the priorities from the city council and from the public by coming to workshops, community meetings. And if you're saying it's trash on swales, then we need to sharpen our eyes for trash on swales. Chris will tell you that I call him probably once a month when I see landscapers out there blowing all the garbage into the street, and then the cars come by and it makes the cars dirty, gets in our storm drains, and basically they're violating the city code because they have to collect the trash from their property.
Yes.
So if I see a code violation, I make it known, whether it's to Chris direct, whether it's to an officer, I report code violations as I come across them. And I would encourage everybody to do the same. As you come across code violations, report them. Code enforcement's out there, the police department's out there, but the more eyes that we put out there, and when we see the type of complaints that come in from the citizens, then we know what type of complaints the citizens value out in the community. So we focus our attention on the trash, we focus our attention on abandoned vehicles, where do we focus our attention to?
Well, speaking of, may I finish? Speaking of that, speaking of the people that do the lawn services, their trucks are getting bigger and bigger and bigger, and they're parking at, like my little road. It's a narrow 2-lane road. So whenever a truck comes on with their riding lawnmowers and all that other stuff, we almost have to go into the easement of the house across the street, which I don't want to do, and I'm not going to do it, you know. But I've seen this happen. So how can we stop with these? I've asked them, I says, can you not have the homeowners, have them drive up into your driveway? But the business people don't want to back out their truck.
Correct. And I mean, if they're actually blocking the roadway, you can always call the police department out there and we will send somebody out there. It won't be our top priority call, but we'll make somebody available to go out there and speak with the landscaper, educate them. But as long as there's not a double yellow line, like on Jet, I think there's a double yellow line in some parts on, there's not.
No, Yacht Club has it, but I saw it on Yacht Club also.
If there's a double yellow line, they should not be blocking the lane of traffic. If there is no double yellow line, they can block it. And then unfortunately, you need to wait or go around them, but they need to leave a reasonable amount of clearance for at least one vehicle to pass by them at all times. Generally, most of the landscaping trucks are good. They park generally towards the edge of the road. There may be a few every once in a while that may don't get all the way over the edge. But it's one of the things, and I can tell you, this is written numerous parking tickets that he's been out there, and that's one of the ones that he's also looking for, is that in the state statute, you have to be within a foot of the edge of the roadway if you're parked on the street. So he's going out there looking for some of those vehicles that are parked more in the middle of the roadway than within 12 inches of the curb or the edge of the roadway.
Yeah. Thank you, because I'm seeing a lot more. Yeah.
Other comments from council? All right. Inputs from the, Mr. Mead, go ahead.
For our next meeting, I would like to add 11.3 where we can take action on code enforcement items during our regular meeting.
Pencil that in and we'll add it to the.
11.3?
Yeah.
I didn't see 11.3. Or city council.
Mayor.
Yes.
Chris, are you finished with your presentation? I know we kind of
Yeah, I
jumped
think
all
we hit
over
all
the
the points. I
place.
did put this slide up because we kind of talked about some of the priorities. I did list, there's about a dozen here of our common violation types, and these are generally ranked in what we typically deal with as far as our priorities and what we see. So if there's any discussion, we can certainly have it or not. But I did want to show, I mean, this is the news in general. It's pretty wide, pretty broad, but it covers a lot of these issues we deal with on properties. Pool maintenance. I know we dealt with some of these real bad pools. Permitted uses, that goes back to lure vessels or any other businesses or uses that aren't allowed on properties. Permit required. That's any of these people doing work on property without permits. And then, on down the list, I won't read through them all, but I did want to show, here's kind of a somewhat of a current priorities ranking. I'll say, if we get any complaint, like Chief said, for us to know about it, we'll go out there, as quickly as possible and inspect it and take action that we can. So as far as that's concerned, we don't rank those. We just go out there as quick as we get them and do it. If there's stuff that we see, driving around, we do generally try to kind of prioritize them in this kind of order here. Some of those, I know you talked about the trash containers, that's what we certainly see. I'll say currently it's definitely probably the lowest priority of the common things we see versus everything else on the list. But I did just want to show this, and that's all I have there.
I have another question.
Yes, ma'am.
Shipping containers. Last month, you said no shipping containers can have sleeping quarters and and there are no more than one shipping container per yard. But yet I'm seeing 2 shipping containers on Raynell, I think it is. And then And then I sent you a picture of 204 3rd Street, nicely painted, has a window in it, electricity, nice, all that. Shipping container.
Yes.
And then someone's living in it.
Yes, so shipping containers, the ordinance that was approved was specifically for using shipping containers for storage, like a shed. Shipping containers can still be used as a accessory dwelling or a primary dwelling if they meet the building code, and they can be used for commercial use. The ordinance that we have in place now specifically regulates how they are to be used as a storage building.
So are they only supposed to have one?
They can only have one. Now, if it was in existence prior to the ordinance, it's non-conforming.
So they grandfathered in?
It's grandfathered in. If they want to change it, move it, then they'd be told, no, you can't. Basically, there's a process to modify or change non-conformities to our LPA, but those are existing non-conformities. They're grandfathered in basically. But going forward, if someone came in saying, "I want 2 shipping containers as storage buildings in my yard," we're going to say, "No, you're allowed as one, and here's the rules."
So same thing with pergolas and easements, they can be grandfathered in?
Existing ones.
Grandfathered in before what date?
It depends on when the code was in place.
When was the code in place that they could be on easements?
The current land development code has been in place since 2012. There was a prior land development code before 2012. We'd have to go back and research the specific language for easements, but current land development code has been in place since 2012. All of that's been in place, but prior to that, though, because that update in 2012 was not a
2012
current code. Now, so there was prior land development code going back, 30 plus years, but current code is what we enforce to. If it doesn't meet current code, it's a non-conformity.
It was interesting, I read on the listing of the easement, the definition of the easement at the enjoyment of the property owner, that they can use the easement for their enjoyment. they don't have to mow the grass on the easement, and they don't have to, they can let the city come mow the grass on the easement.
No, they're responsible for cutting grass on easement and even in the right of way abutting the property towards the street. That is in the code that, in fact, it falls into some nuisance requirement that they're responsible for maintaining that area.
Yeah.
Anyone else on council have comments? Anyone from the public want to comment? Come forward and identify yourself and limit your comments to 5 minutes.
Mayor, Council, my name is Robert Lynn. I live in this Elliott Point neighborhood. I've been on the compliance board for pre-COVID. So I want to divide my comments into two halves. First, I've walked around my neighborhood. I have 2 dogs. I walk them every night. I've walked past the same house for 9 years. That is a derelict house. Sitting on the code enforcement board, I was told that this house was being fined X amount of dollars a day and that there was nothing they could do because it was a homestead home. It has gotten worse over the 9 years. It must be driving the people that live adjacent to it crazy. And one of my frustrations of having sat on the code enforcement board all those years was that the city took no action against houses where the assessed fees were greater than the value of the property. And if I could be king for a day, that is something that I would focus my efforts on. There has to be a number of these residences in the city that are in excess of fines greater than the value, and we need to take action against those houses. I often felt as a code enforcement member that we needed more documentation on the process. There were a number of people that would always come and say, as Mr. Fressetti said, oh, I didn't get the notice, I didn't get this. And we would hold up the little green sheet or whatever. And yes, documentation, I think photographs, videotapes, working with the police force would have stopped a lot of the nonsense, because as the citizens on the board, you have to give some credence to somebody saying, I didn't get a notice. You can't look at them and say you're lying, although you think they're probably pulling your shoe, but you have to give them some credence. I took exception, and please don't be offended, Mrs. Barnes, I went back to the minutes through 18. There was only one meeting in the 6 years I sat on the board where we did not meet because we did not have a quorum. So this number of 6 or 7 or whatever may in fact be true, but it wasn't from people sitting at the meeting and having to disband because there was a quorum. There were some canceled meetings, and the staff may have had prior knowledge that members weren't going to attend and the meeting was canceled. That was not broadcast to the people who sat on the board. So it could be 6 or 7, but from my perspective, in 6 years, there was one meeting where we did not have a quorum and had to move the business to the following month. We always ask the representatives, Mr. Burns, that what was the technical violation and what was the board's responsibility for enforcing the code. I will say that we used waiving the administrative fee as an inducement to getting people to be compliant. And a substantial number of people that came before the Code Enforcement Board had a lack of resources to do things. And if you said it's $325 just to hear you talk to us, then you could see well, just find me till hell freezes over. So we used it as an inducement, but in my personal experience, we did not waive the standards. We always relied on the expertise of the staff to tell us what our jurisdiction was. I am aware of the anonymity. I ride my bicycle around the neighborhoods here. I actually have a voice recording on my iPhone, and I would ride by and say, this house, this house, this house. When I was told that then my name was going on all of those complaints, I had to seriously think about, did I want my name going to the code enforcement people with 30 or 40 complaints? On my typical 10-mile ride around this town, I can give you 30 or 40 violations. So I'm still wrestling with that in my mind. I think in my personal feelings was that the magistrate was not addressed to the Code Enforcement Board, and we felt that the rug was yanked out from under our feet. That suddenly our meetings stopped, there was a magistrate, you were no longer needed, we never even got a thank you or a goodbye. Where I would like to go with this in the future is I think that what I've learned this evening as a code enforcement volunteer has been eye-opening about the number of issues that the city is facing with code enforcement. If the belief is the Code Enforcement Board is not acting as professionally as a trained magistrate, then we need the education so that we can actually act like the magistrate and be more cognizant of the codes. So maybe the meeting needs to start at 4. We get a 30-minute indoctrination or an upbrief of what's changed, what pressures the city is feeling from the code enforcement staff, and then the hearings start at 4:30, where we deal with the citizens as the citizens sitting behind the table. Those are my experiences for the last 6 years. I wanted to share those with the board. The other little minuscule thing is we used to get a reminder from Mrs. Van Etten. The board is a week away, the board is 3 days away or whatever. When she retired, that kind of stopped. I thought that led to some of the issues that maybe the outside agencies were perceiving the board wasn't functioning. We all have busy lives, but I always relied on those emails of, yes, it's in my calendar, but I got an email from Mrs. Etten saying, hey, it's in a week. I always felt that was helpful. Thank you for your time. I appreciate everything I've learned this evening. Thank you.
Thank you, Mr. Reed. Yes.
Good evening, I'm Peggy Mitchell, and I just wanted to make a comment about the letters that are sent out because I'm a code violator and I'm in the process of making sure that I come up to code and pay my fines, and the code enforcement officers at the office have been very helpful. It was just that first letter when it says it's not $250, it's $250 every day up to everyday fines. And I just want to clarify that because that in itself put me in a tizzy and created a great deal of panic on my part since I don't have a lot of income. And so I reached out to several people to share that with them. So I don't know, when they posted it up on there, when Chris did, it just said $200 up to $5,000, or that made it sound very simple and low. But in reality, the letters that they send out, the registered letters, it cites that violation. I was told that that's to put the fear in you, to make sure that you come up to code and do what you're supposed to do. But even after I talked with the code enforcement officers, and they knew my plight, hospitalization, trying to save money, whatever it was, I still got a letter. And I took umbrage at that. It kind of hurt my feelings to know that I'd been working and doing what I was supposed to do, and yet I still got that code violation, that registered letter. I think I got 7, actually, in total. So perhaps there's another way to make it a little bit friendlier and a little less intimidating for an ordinary average citizen who isn't used to breaking the law. And I don't know if that can happen with the code enforcement officers. But I appreciate you letting me give this input. Thank you.
Thank you, Ms. Mitchell.
I feel like I'm in a special meeting. I'm too am a code violator. Anyway, I'm the neighbor of Peggy Mitchell, Sharon Trineri, and I too have taken great pride at being a member of the Code Enforcement Board again. I was a member of the Code Enforcement Board for several years, about 10 years ago. And I can share with you, somebody, I've forgotten which one, asked about the Order 1 versus Order 2, and Bert said, or Mr. Rhodes said, that we're pretty lenient on the Order 1. And we are, because there's interplay between the violator and the board. And I think that makes us a friendly city. And we try to we as board members try to understand what the issue is and why were they not in compliance, and what do we have to do to help you get into compliance before the Order 2 is issued. So there's an interplay that takes place when we're on the code board. Now, when I appeared in front of the special magistrate, which the city had to pay for 2 of them because there was a conflict of interest, so that to me was a waste of money of the city to have to hire another attorney because I had a relationship with that law firm. I lost my train of thought. When I was in front of the special magistrate, I dared to ask a question, and she told me I was out of order. She would not even entertain my question. And then she got so upset, and I, honest to goodness, I have no clue what upset her. But because I hadn't said a word, and I know my personality is a little strong, and some people just, you either like me or you don't, but she just really got upset with me, and she goes, well, we're not gonna waive this fee because, I didn't even ask her to waive the fee. But I was so stunned at her reaction to me that was so aggressive. And I've never seen that as a member of 2 different code enforcement boards. So I would like to make a suggestion, because since I've been a violator, I have done a lot of studying about the code enforcement, and I have gained a great deal of respect for Chris's office and for Bert. I've known Bert a long time, more than 20 years. And so we maybe argue, but I have gained a great deal of respect for this office and all the things that they contend with. And I would like to make a suggestion that we retain the Code Enforcement Board, because the volunteers do take pride in being a participant of the city functions. And what if, or I would like you to entertain, that perhaps keep the special magistrate for commercial properties? Because I know as a real estate broker, I have to let the public know that I am a broker because I have more knowledge than the normal citizen walking down the street. And all the people, and like Ms. DeBerry said, I asked a lot of people, I'm saying probably close to 500 people since the last time I appeared here, and nobody wants the special magistrate, not one. So, but I see the wisdom of having somebody that has extra knowledge, and I would suggest that perhaps we keep the special magistrate for commercial properties and keep the code enforcement board that is made up of citizens for residents. That's just a suggestion. Then we would have both situations. I have several notes and now I can't read my notes. And I agree with the, I'm working with Tim and the code enforcement people about my violation. It's gonna take a little while because I'm not as computer literate as I wish I were, and I'm finding this program very difficult to work with. But I've met with Tim, so I'm working on it, and I'm going to get everything in compliance. But I acknowledge I've probably been a little stubborn because I took this personally, which is why I started studying the statutes and understanding what they're dealing with.
Ms. Canary, can you wrap it up?
Yes, sir. And so another suggestion, because of the frustration, and this is going to go down sideways. I already know this, but I just want you to think about it, that and I've read it, that's a statute that you have to give, you're required by the law to give your name and address when you report a violation. I understand that. I think that's wrong, but I understand it. But it's frustrating to walk through our neighborhoods and see things that we would like to report, but we're not going to report because we don't want our names out there because of retaliation. So what would you think? You know, these lawn companies put these little signs in your yard. So what would you think if we had code enforcement, if somebody's got a violation that they notice, that they could put a little sign that says, there's a report, there's, you know, this property is in violation. That does a couple of things. It kind of shames the person who's in violation. It lets the neighbors know that this has been reported, that there's not it's not being ignored, and people would maybe come into compliance a little more quickly. Again, I'm just making a suggestion. Shut up, Sharon, is what you're saying. Okay. I think that was, is there any way to change that? Short of going to the legislators?
No, you'll need to lobby, Mr. Mayor, Representative Maney on that one.
Okay, because that's, anyway, I just want you all to know that as upset as I got with code enforcement, I have gained a great deal of respect for that office. Thank you for your time.
Thank you, ma'am. Anyone else? All right, we're going to wrap this workshop up. I think it's clear that we up here, this body, we want enforcement, and the council wants to help in that process. And we're going to add it to the agenda for this next meeting coming up. So with that being said, we're going to